You're pulled over. The officer asks you to blow into a breathalyzer. Your mind races. If you blow, the number could convict you. If you refuse, what happens now? That single choice has just become a legal minefield where either answer can lead to a pair of handcuffs. I'm Rick Fletcher, a Florida criminal defense attorney. My firm has been on the front lines dissecting every word of the new DUI statute known as Trenton's Law since it was signed. And in this video, I will walk you through exactly what this powerful new law does, explain the devastating penalties you now face for a refusal, and give you the critical knowledge you need to protect your freedom. So let's get started. Welcome to the channel. For years, I've dedicated my career to defending people accused of crimes here in Florida. Today, we have to talk about the most significant and dangerous change to our state's DUI laws in over a decade. As of October 1st of 2025, House Bill 687, better known as Trenton's Law, is officially in effect. This isn't just about higher fines or longer license suspensions. This law fundamentally changes the game for anyone pulled over on suspicion of DUI. It creates a new crime and doubles the prison time for others. What you thought you knew about refusing a breathalyzer is now wrong, and that mistake could cost you your liberty. To understand why this law is so aggressive, you have to understand who it's named for. This was Trenton Stewart. In 2023, he was a student and a beloved football player at Stetson University. His life was tragically cut short when he was killed by a drunk driver in Jacksonville, Florida. This tragedy, like so many others, sparked outrage and a call for action from advocacy groups and lawmakers who felt the existing laws had loopholes that allowed dangerous drivers back on the road. The goal of Trenton's Law was to close those perceived loopholes and get tough on two specific areas: people who refuse to take a breath test and people who repeatedly kill others while driving impaired. So, what did the law used to be and what is it now? Let's break down the two major changes. Change number one, refusing the breathalyzer is now a crime on the first offense. This is the big one that affects everyone. The old law, now before October 1st, 2025, if you were arrested for a first-time DUI and you refused the breath, urine, or blood test, the penalty was a civil penalty, not criminal. Your license would be suspended for 1 year under Florida's implied consent law, but you were not charged with the crime for that refusal. The only crime you were fighting was the DUI itself. A second refusal was a misdemeanor, but the first was not. Now Trenton's Law, the new law, that has changed everything. Under Trenton's Law, a first-time refusal is now a second-degree misdemeanor. This is a separate criminal charge punishable by up to 60 days in jail and a $500 fine. And this is in addition to the 1-year license suspension. And in addition to the original DUI charge you're still facing. A second refusal remains a first-degree misdemeanor. Change number two, doubled penalties for repeat DUI manslaughter. The second part of the law targets the most serious offenders. A DUI conviction for DUI manslaughter was a second-degree felony punishable by up to 15 years in prison. Now, under Trenton's Law, if a person has a prior conviction for DUI manslaughter, BUI manslaughter, or vehicular homicide, a second offense is now a first-degree felony punishable by up to 30 years in prison. The law effectively doubles the maximum sentence, sending a clear message that the state will seek to permanently remove these offenders from the road. Let's put this into a real-world context. Imagine you're pulled over after having 2 beers with dinner. You're not drunk, but you're nervous. The officer arrests you for DUI and asks you to blow. Under the old law, the calculation was simple for many. Refuse the test, take the 1-year license suspension, and make the state prove the DUI case without a breath score. Under Trenton's Law, the calculation is a nightmare. If you blow and you're over the limit, you've given the state its best piece of evidence against you for the DUI. If you refuse, you are now fighting 2 separate criminal charges, the DUI and the crime of refusal to submit to testing. And here's the scary part. The refusal charge is often easier for the state to prove. To convict you of refusal, the prosecutor only needs to show that the officer had probable cause to arrest you for DUI, that you are properly read the implied consent warnings, and that you still said no. They don't need to prove you were actually impaired. This gives prosecutors immense leverage to pressure defendants into taking a plea deal on the DUI charge. Now, mistakes people make under the new law. 1, thinking refusal is not a big deal. The biggest mistake is not understanding that I refuse now means charge me with a crime. It is no longer just a DMV issue. Arguing with the officer. Trying to negotiate or argue about the law on the side of the road will not help you. You cannot talk your way out of it. Everything you say is being recorded and can be used against you for both charges. Answering questions after refusing. Once you refuse, you should invoke your right to remain silent. Many people refuse the test, but then continue to talk, often admitting to drinking or making other statements that the state will use to prove the DUI charge. Waiting to hire a lawyer. With 2 charges and a license suspension to fight, time is critical. There are strict deadlines, like the 10-day rule to challenge the administrative suspension of your license. Waiting is the worst thing that you can do. So, what should you do? This is a complex decision, and there is no one-size-fits-all answer. As a lawyer, I cannot tell you whether to blow or to refuse, but I can give you a framework for making the smartest possible choice in a terrible situation. If you are confident you are under the legal limit, submitting to the test may be your best option to quickly resolve the situation and prove your innocence. If you know you are significantly over the legal limit, refusing the test will deny the state its strongest evidence for the DUI. You will be charged with the crime of refusal, but it may give your attorney a better chance to fight and win the more serious DUI charge. You are essentially trading one problem for another, but potentially a less severe one. Regardless of your choice, invoke your rights immediately. After you make your decision on the breath test, you must say 2 things clearly. Officer, I am going to remain silent and I want my lawyer. Then say nothing else. Trenton's law has created a new and dangerous landscape for drivers in Florida. Navigating it without an experienced guide is a risk you cannot afford to take. If this video gave you a clear understanding of your rights under this new law, please hit the like button. It helps the video reach and educate more people. Subscribe to the channel for more essential legal updates. And if you or someone you care about has been arrested for a DUI or refusing a breath test in Florida, call my office now. The strategies that worked last year are obsolete. You need a defense built for this new reality. My contact information is in the description below. Thank you for watching. Stay informed and stay safe.